Good evening, ladies and gentlemen. I'm Driti and you're watching Skyline. Every single day, thousands of Indians living in the United States, they wake up wondering just one thing. Has another immigration rule changed overnight? Will this affect my visa, my green card, my taxes, or even my job? Well, the reality is that immigration in America, it is no longer just about paperwork. It has become about career security, financial freedom, and peace of mind. So, that's exactly why we are here. Tonight, I have 10 major stories that every Indian in the US, every H-1B worker, every student, every green card applicant, every NRI, and every American should know. Some of these changes could save you thousands of dollars. Others could completely change how you make career decisions. So, let's start with the story that could finally end a fear many foreign professionals have silently lived with for years. Well, for years, many foreign professionals believed that they had landed their dream job in California. A prestigious company, a good salary, and a visa sponsorship. Everything looked perfect. But hidden deep inside the employment contract was one condition that very few people really notice until it was too late. If you leave the company before a certain period, you will have to pay thousands of dollars. Sometimes it was $10,000, sometimes $20,000, in many cases even more. Now, these clauses covered immigration lawyers' fee, green card processing expenses, visa filing costs, in fact, relocation expenses, and so-called replacement cost. For many H-1B workers, this wasn't just a clause. It became a cage for them. People stayed in stressful workplaces, accepted delayed promotion, ignored toxic environments simply because leaving the company meant receiving a huge legal demand asking them to pay thousands of dollars. Many employees didn't stay because they loved their job. They stayed because they were afraid of the bill that was waiting for them outside the exit door. Well, California has now stepped in. Ladies and gentlemen, a new law, Assembly Bill 692, has changed the whole equation. Well, from now on, companies in California can no longer use these broad stay or pay agreements to trap the employees. If an employer tells you leave the company and repay your immigration expenses, that clause could now be legally unenforceable under the new law for qualifying agreement here. Well, it is a significant shift because California is home to Silicon Valley, where thousands of Indian engineers, software developers, AI professionals, and green card applicants work. But yes, before anybody celebrates, there is another detail. This law does not mean every repayment is automatically illegal. There are limited exceptions though. For example, genuine sign-on bonuses or certain education-related agreements may still be allowed, but only if they follow strict legal conditions. The repayment must be fair, it must reduce over time, it cannot suddenly become due just because somebody resigns. And in many situations, employees must even be given enough time to seek independent legal advice before signing it. In simple words, California is sending a clear message. A company can reward loyalty, but it cannot purchase it through any sort of fear. Well, for thousands of Indian professionals who have felt trapped between protecting their visa and protecting their finances, this could be one of the biggest employment changes of the year. And yes, with the layoffs, reconstructing and hiring slowdowns continuing across the tech industry, knowing your legal rights has become just as important as having technical skills. Because today, your biggest career protection, it may not be a coding ability. It may be your understanding of the law. And yes, speaking of protecting your money, our next story is about something many Indians don't realize until they receive an unexpected notice from the IRS. Selling property in India may look like a very simple financial decision to you, but for many people in America, it can quietly turn into a costly tax nightmare. Well, for many Indians in the US, selling property in India feels like the end of financial chapter. You sell your ancestral home, an apartment, and investment property, pay the tax in India, transfer the money, and move on. Sounds simple, right? Well, not if you are a US tax resident. Because while you may think that the whole transaction is over, the IRS could be looking at the very same sale from a very complete different angle. Now here's why it matters. If you are living in the US on an H-1B visa, a green card, or if you are a US citizen, America taxes your worldwide income. That means even though the property is in India, the profit from selling it still has to be reported on your US tax return. And I've repeated this again and again. Many Indians assume that once they have paid tax in India, they are done. Unfortunately, it's not true. Well, let's start with the first trap here. In India, many people use legal exemptions like Section 54 and Section 54 EC by reinvesting the money into another house or certain government bonds. This could reduce or even eliminate capital gains tax in India. Sounds like a smart tax saving move, right? But here's the catch. Since you didn't actually pay tax in India because of the exemption, you may not get a foreign tax credit in the US. And if there's no tax credit, the IRS could tax your entire capital gain. And yes, then comes the second surprise. Even if you pay full tax in India and claim a foreign tax credit on your US federal return, some American states don't recognize that credit. States like California, states like New York, New Jersey, Massachusetts, these states can still tax the same income. So yes, one property sale could lead to the tax in two different countries and even at two different levels inside the US. And there's one more complication that catches many people off guard. Currency exchange. The IRS does not calculate your gain in Indian rupees. It calculates everything in US dollar. If exchange rates changed between the time you bought the property and the time you sold it, it could end up showing a larger taxable gain in the dollar term, even if your actual profit in India was small. In some situations, people have even faced taxes on what feels like a paper gain. That's why financial experts say that selling property is no longer just about finding the right buyer. It is also about planning the transactions before you sign the sale deed. Understanding how Indian tax rules and US tax rules work together, it can save you from any sort of expensive surprise later. Because in cross-border taxation, what you don't know can end up costing you far more than what you earn. And yes, taxes are becoming more complicated, but getting a job in America is becoming even harder. And our next story explains why thousands of foreign professionals sitting outside the United States, they are suddenly finding the H-1B dream slipping away. Well, for years, thousands of skilled professionals in India, they dreamt of getting that one particular email from the US company. A job offer, an H-1B sponsorship, a chance to build a career in America. But today, many companies are quietly changing the way they hire. They are not announcing it publicly. They are not sending the emails about it. Yet, inside corporate legal departments, a major shift is already underway. More and more employers, they are choosing to sponsor people who are already inside the US instead of hiring candidates directly from overseas. Well, what is the reason behind all this shift? It's very simple. Because hiring somebody from abroad, it can become far more expensive and legally uncertain for them now. Ongoing legal battles over the proposed $100,000 counselor processing fee, it has made many companies rethink their hiring strategy. Even though the policy continues to face court challenges further, businesses don't really want to take the financial risk right here if the rules change during the hiring process. So instead of recruiting talent directly from India or other companies, many employers, they are focusing on people who are already in the US. Students on STEM OPT, H-4 visa holders with work authorization, or professionals who are already maintaining a valid immigration status, everybody has suddenly become much more attractive candidates for them. For employers, it's easier. For applicants sitting outside America, it is becoming much more difficult. But even if you're already inside the US, the challenge that does not end there. While here, maintaining your immigration status, it has never been more important. A small mistake like letting your status expire, working without authorization, or even traveling outside the country while certain applications are pending, it can create serious complications for you. In some cases, international travel during the wrong stage of H-1B process, it can force the case into consular processing, exactly what many employers are trying to avoid. And that is why several companies are now advising employees just to avoid unnecessary international travel until their immigration paperwork is fully approved. Something as simple as attending a family wedding abroad, it can become a legal complication if the timing is not right. The message from corporate America, it is becoming clearer every single day. Companies still need skilled professionals, we do agree. But they also want fewer legal risk, fewer delays, and fewer uncertainties. For professionals who are already in the US, protecting your legal status, it is now just as important as preparing for your next interview. And yes, for those waiting overseas, the competition has become tougher than ever before. The American dream is not disappearing, but the pathway to it, it is becoming narrower. And understanding the new rule, it could mean a lot to you, and it could make all the differences. In the meantime, finding a new job is difficult enough, as I said, but what happens if you lose your job before finding another one? Well, in our next story, we will look at the immigration strategy thousands of laid off H-1B professionals are now using to buy themselves more time in the US. Well, losing a job is stressful for anyone, but for an H-1B worker, losing a job, it is much more than losing a paycheck. It starts a countdown that could decide whether you stay in America or you leave the country. Well, under the current immigration rules, most H-1B professionals get a grace period up to 60 days after their employment ends. Now, on paper, 2 months sounds like enough time for you. But today's hiring market tells a very different story. Interview stretches for weeks, technical rounds take longer, salary negotiations continue for days, and by the time you finally receive an offer, those 60 days are already over. And that's exactly why thousands of laid off professionals, they are now turning to what immigration lawyers call the B2 bridge strategy. Idea very simple. Before your 60-day grace period expires, you file the form I-539 just to change your status from H-1B to B2 visitor visa. Once that application is properly filed, you enter what's known as period of authorized stay, allowing you to remain in the US while USCIS processes your request. Now, for many people, this becomes valuable extra time to continue interviews, attend networking events, and search for another employer who is willing to sponsor an H-1B petition. But don't mistake this for an easy shortcut. USCIS is now examining these applications much more closely than before. Officers want to know why you are requesting visitor status now. They want proof that you can financially support yourself without working. They also want evidence that your stay is temporary and that you will continue to become a non-immigrant, and that should be your intention. In other words, simply writing, "Hey, I'm looking for a job," it is not enough. Well, applicants now need to show bank statements. They need to explain how they will pay their living expenses, and they need to demonstrate that they are following immigration rules very carefully. Any missing document or weak implementation, it can trigger request for evidence, or in some cases, even a denial. There's another important rule that many people don't realize. If your B2 application is pending, you cannot work. Not for a US company, not remotely from any other employer. Well, not as a freelancer, even not as an unpaid worker that resembles employment, that can create serious immigration complication. Now, let's say that you finally receive a job offer. Your new employer files an H-1B petition while your B2 application is still pending. Now, that creates what's commonly known as bridge between the two applications. Corporate immigration lawyers, they often use premium processing to make sure both cases move through USCIS in a correct sequence, helping the employer return to H-1B status without leaving the country. Well, for thousands of foreign professionals, this strategy has become an important lifeline. But it's also a reminder that immigration is becoming much more technical every year. One missed deadline, one incorrect filing, or one unauthorized job, it can change the entire outcome of your case. Today, surviving a layoff, it is not about finding your next employer. It is also about making sure your immigration status survives the journey with you. And yes, immigration paperwork isn't the only thing that is changing. Even moving your money from India to the US has become much more complicated. And if you are an Indian in the US planning to transfer funds home. The next update, it could completely change the process you have followed for years. Every single year, thousands of Indians transfer money from India to the US. Some are selling family property, some are moving rental income, others are bringing inherited assets or their personal savings overseas. For years, this process followed a very familiar routine here. Your chartered accountant prepared Form 15CA and 15CB. The bank checked the document and the money was transferred. Well, that process has now changed. The Income Tax Department has introduced a new compliance system. The old Form 15CA and 15CB, they are being replaced with Form 145 and Form 146, creating an entirely new digital framework for outward remittances. At first glance, it may look like nothing more than a change in form number to you. But in reality, the government is changing the way cross-border money transfers are monitored. Under the new system, Form 145, that becomes the declaration submitted before money is transferred abroad. Form 146, prepared by the CA, certifies whether the tax on that transaction has been correctly calculated and paid. And here's where things become important. This isn't just paperwork sitting inside a bank branch anymore. No. The information is digitally linked with your PAN, your income tax records, and your annual information statement. Every transfer creates a much stronger compliance trail than ever before. You know what that means? That means if the amount you're transferring does not match your tax filing, or if the tax deducted at source has been calculated incorrectly, then your bank may not be able to process the transaction until those issues are resolved. For Indians in the US, this has another layer of importance. Why? Because IRS already requires the US tax resident to report worldwide income. So the taxes paid in India often becomes part of foreign tax credit claims in the US. If the numbers reported in India does not match the figures reported to the IRS, both tax authorities now have far greater visibility than they did in the past. Well, financial experts therefore recommend preparing everything well before initiating the transfer. Ensure your PAN details and are updated, your tax filing are complete, and your CA has correctly certified the transaction before approaching the bank. Because once the process begins, correcting mistakes, it can delay your remittance by weeks, maybe, or even longer. Well, for many NRIs, this isn't just about transferring money. No. For the NRIs, it is about protecting years of savings, it is about avoiding unnecessary delays, and it is about making sure that one financial transaction does not create compliance problem in two different nations. And yes, while governments are tightening financial compliance, the US is also tightening immigration enforcement. And in our next story, we will look at why the Department of Homeland Security has taken an unprecedented step that is drawing global attention across the Indian diaspora. Well, when we think about immigration enforcement, we usually picture arrest happening quietly behind closed doors. But this time, the US government has taken a very different approach. Ladies and gentlemen, the Department of Homeland Security, it has done something that has kind of surprised immigration experts and caught the attention of the Indian community across America. It has publicly released details of foreign nationals who are arrested under what it calls its worst of the worst enforcement initiative. Among those listed are 19 Indian nationals. Their names, their photographs, arrest details and allegations have all been made public as part of a broader crackdown targeting serious criminal activities. According to federal authorities, these individuals are accused of being related to large-scale cyber fraud, internet scams, and international financial crime network that allegedly targeted victims across the US. Now, it's very important to understand just one thing here. This action is not aimed at any ordinary visa holder. It is not directed at every H-1B worker, international student, or green card applicant. The overwhelming majority of Indians living in the US, they do follow all the rules. They pay taxes and they contribute to the economy. But this announcement sends a completely different message. It shows that US immigration enforcement is becoming far more public, more aggressive, more technically driven than ever before. Federal agencies are increasingly combining immigration records with financial intelligence, cyber investigations, and international cooperations just to identify organized criminal networks operating across the border. And when those investigations lead to arrest, authorities are now willing to make these cases public. For the Indian diaspora, this is also a reminder that immigration status and criminal law, they are deeply connected in the US. A serious criminal conviction, it does not just lead to prison. It can result in visa cancellation, deportation proceedings, and even permanent restrictions on returning to America. As immigration enforcement continues to expand, though, one thing is becoming increasingly clear. The US government is no longer focusing only on border security. It is also strengthening enforcement from within the country itself. And understanding these policies shift, it is becoming essential for everyone following the immigration news. And yes, while one federal agency is strengthening enforcement on the ground, another one is tightening the rules for people who come to America to study, to teach, to conduct research. And that brings us to our next story. Every single year, thousands of Indians travel to the United States on J-1 exchange visitor visa. Some go as researchers, some work as university scholars, others begin medical residencies or academic training at some of America's biggest institutions. For decades, this visa category, it offered flexibility, allowing the participants to focus on research, education, and professional development. But now the rules are changing. Ladies and gentlemen, the US State Department has proposed one of the biggest overhauls of J-1 visa program in years. And the biggest message behind these changes, very simple. Compliance is no longer optional, it has to be perfect. One of the most significant proposals related to health insurance. That's right. Under earlier rule, program termination generally depended on whether a violation was considered international. Right. Under the proposed framework, even an accidental failure to maintain the required insurance coverage, it could put a participant's program at risk. And it's a major shift. You know why? Because sometimes mistakes happen. Not because somebody wants to break the rule, but because paperwork gets delayed, because policies expire, because administrative issues arise. The proposed regulation also places greater emphasis on documentation though. Participants will be expected to keep their records updated, report address changes on time, maintain accurate educational information, and ensure that every requirement under their exchange program is properly followed. Even administrative mistakes could now attract much closer scrutiny. Another proposal gives authority broader power if a participant's visa is revoked. Sponsors may have less flexibility than before, and program termination could happen much more quickly under certain circumstances. Well, for universities, for hospitals, for research institutions, this means more responsibility. For international scholars, it means more paperwork, and for thousands of Indian researchers and doctors building career in the US, this means paying closer attention to immigration compliance than ever before. Well, the purpose of the J-1 program, it has not changed. America still wants talented researchers. America still wants scientists. They still want medical professionals, but the expectations surrounding documentation, reporting, and regulatory compliance, that is becoming much stricter. Today, success in America is no longer determined only by your qualification. Increasingly, it also depends on how carefully you follow every immigration rule. Well, for many immigrants, following the rules has never been the problem. The real challenge has been waiting, sometimes for decades maybe, and our next story focuses on the proposal that could change that entire conversation forever. For decades, one of the biggest frustrations for immigrants in the United States has been the green card backlog. Thousands of highly skilled professionals have done everything the system asked them to do. They studied, they worked, they paid all the taxes, followed every immigration rule, renewed their visa again and again, and continued contributing to the American economy. Yet, for many, permanent residency still feels painfully out of reach. Now, a new proposal in the US Senate is kind of trying to change the entire conversation. California Senator Alex Padilla, along with Senator Dick Durbin, they have reintroduced legislation that could modernize one of the oldest provisions of American immigration law. The proposal focuses on something called registry provision under the Immigration and Nationality Act. So right now, the law says that only people who have continuously lived in the US since January 1st, 1972 may qualify for the permanent residency under this pathway. Think about that for a moment. The qualifying date has not changed in decades. As a result, the provision has become almost impossible for most migrants to use it. The new proposal wants to replace that outdated cutoff with a rolling 7 years residency requirement. In simple words, instead of relying on a fixed date from 1970s, eligibility would gradually move forward over time. Anyone who has continuously lived in the US for at least 7 years, maintained a clean record, and met other legal requirements could potentially qualify under this updated framework. Well, supporters believe that this could provide hope to millions of migrants who have spent years building their lives in the US. In the meantime, for the Indian diaspora, this proposal has attracted particular attention because many highly skilled professionals, they remain stuck in employment-based green card backlogs. Some families have waited for years. Children have grown up in US only to face uncertainty about their own immigration future. Many professionals continue renewing temporary visas while waiting for permanent residency. Now, naturally, this proposal has generated excitement, but there's an important reality check. At this particular moment, it is still a proposed bill. It has not become a law. Before any of these changes can take place, the legislation must move through Congress, secure enough political support, and complete the full legislative process. In other words, nothing changes overnight, right? But still, the introduction of this particular bill, it sends an important signal. Immigration reforms remains part of the national conversation, and lawmakers continue looking for ways to address long-standing problems in the entire system. Well, for millions of immigrants, hope often begins with the proposal. Whether that proposal eventually becomes law, it is a question only time and Congress will answer. Well, immigration isn't the only thing affecting people waiting for green cards. It is also creating major challenges for American companies trying to keep their employees legally at work. And that is exactly our next story. Can you imagine arriving at work on a normal Monday morning? You switch your computer, you open your email, and before you even begin your day, your employer calls you into a meeting. Not because of your performance though, not because the company is downsizing, but because your legal permission to work, it has suddenly changed. Well, that situation, it is becoming a reality for many workers across the United States. Ladies and gentlemen, following recent court ruling and changes to humanitarian immigration programs, many employers are discovering that employees who are legally authorized to work, they are suddenly facing changes to their work status. Across industries like healthcare, logistics, hospitality, and even tech, HR departments are checking the federal E-Verify system and finding that some employees are no longer authorized to work in the US now. Well, this has placed many companies in an extremely difficult position. If they knowingly continue employing somebody who no longer is authorized to work, they could face serious penalties under the US immigration law. But if they terminate the employees too early or ask for unnecessary immigration documents, they could also face legal challenges for discrimination. In other words, employers are walking a legal tightrope. For foreign nationals, this situation is equally stressful. You know why? Because many workers believe that automatic work permit extension, it would continues as they had in previous years. But changing policies and court decisions, it has kind of created uncertainty in several immigration categories now. So that basically means checking your immigration document, it is no longer something that you do once every few years. It has become something you should monitor every single month. Well, know your work permit's expiry date. In fact, track every immigration notice, respond quickly to government correspondence. And if you are changing visa category, make sure that every filing is submitted on time. Because let's be honest, in today's immigration environment, one overlooked deadline, it can affect your job, your income, and your future in the United States as well. Well, for the employers, compliance has become more demanding. In fact, for employees, awareness has become more important than ever before. Tonight, we have covered visa, taxes, green card, financial rules, and immigration enforcement. But before we end today's show, there's one final story that raises a very difficult question. How secure are systems designed to protect America's financial investigations? Let's talk about the most talked about agency in the world, the FBI. But what if somebody caught an FBI agent? Well, when we talk about cyber crimes, we usually think about hackers sitting behind computer screens, trying to break into government systems or steal digital assets. But what if the person accused of stealing the money wasn't an outsider? What if he was a trusted one? Well, that's exactly why this case has stunned the entire US. The US Department of Justice has charged an FBI supervisory special agent with allegedly stealing nearly $1 million worth of cryptocurrency from digital wallets that were under federal investigations. That's right, under the court document, the agent allegedly used this high-level security clearance just to gain access to sensitive government system. Here, investigators say that he transferred cryptocurrency from wallets that were already being monitored by federal authorities during national security and counterintelligence investigation. Wait, can you think about the irony here? The person responsible for protecting the evidence is now accused of stealing the very evidence. Federal investigators allege that the transactions happened over a period of time and that the cryptocurrency was moved through different digital platforms in an attempt to hide its trail. But perhaps the most surprising detail in the entire case involves AI. According to prosecutors, investigators found that the agent had allegedly used ChatGPT while planning his future. Court filing claims he searched for information about how much money somebody would need to retire comfortably in Europe and even explored plans for buying agricultural land in Portugal. Now, it's very important to remember that these are allegations presented by federal prosecutors, and the criminal case will ultimately be decided through the legal process here. But regardless of how the case unfolds, it raises some important questions. If somebody working inside one of the world's most powerful law enforcement agencies can allegedly misuse access to sensitive financial system, what does they say about internal oversight? How secure are digital assets once they become part of the governance? And as the cryptocurrencies become increasingly common now, are existing monitoring systems strong enough to prevent the abuse from both outside hackers and insiders with authorized access? This case, it also highlights how seriously the US authorities are treating digital financial crime. Now, whether the suspect is an outsider, a corporate executive, or even a government official, investigators are making it clear that nobody is considered above the law. Tech continues to evolve, digital assets continue to grow, and governments around the globe are racing just to ensure that laws, investigations, and accountability keep pace with that particular change. Ladies and gentlemen, with that, here we come to the end of today's edition of Skyline. Today's stories may have covered different topics: employment contracts, taxes, H-1B visas, green card, financial transfer, immigration enforcement, work permit, and even cryptocurrency. But they all carried one common message that the crime, it will be reported. I'm Driti. You have been watching Skyline. Thank you so much for joining. Take care, stay informed, and I'll see you in the next episode.